I call the Honourable Member Dennis O'Rourke.
Mr Speaker, New Zealand First will support this bill to the Select Committee with the hope and expectation that with amendment we will be able to continue to support it thereafter. The bill would enable a victim of violent crime or a close family member, if the victim has died, to obtain a non-contact order against an offender where the offender has been convicted and sentenced to imprisonment for 5 years or more. Fear and anxiety about unwanted contact with the offender can be as bad as the offence itself. A fundamental duty of the state is to protect victims, and we think that this bill is very much overdue. In fact, the government has been rather slothful in progressing it to date. New Zealand First wishes to assist its passage through the House as expeditiously as practicable. I am unable, however, to agree with the Greens that the existing protections are adequate. Yes, there are existing ways in which people can get these protections, but they are not easy to use. This bill, I think, is needed, but I have a number of suggestions to make so that the bill might be as effective as possible. The first concerns Section 5, which defines violent offender as a person who has been convicted of a violent offence that affected the victim and who has been sentenced to a term of imprisonment for 5 years or more. That definition is quite narrow, and I suggest that it should be widened. Instead of requiring sentencing to a period of 5 years or more, I suggest that it would be more appropriate instead to only require sentencing of an offence punishable by 5 years imprisonment or more. That would broaden the scope of the legislation to capture offenders whose sentences are less than 5 years, but who had committed an offence serious enough to enable a court to sentence for 5 years or more. After all, if the offence was so serious as to attract imprisonment at all, then the victim should be able to use this new law. Another issue concerns Section 7, which provides that a victim may apply to a district court for a non-contact order in respect of a violent offender, and that an application may be made at any time after the offender is released from imprisonment. That requirement that an application must be made after the release of the offender from prison is, I think, too late. The victim should be able to apply for the order at any time after the conviction, so that the court can make an order to have effect immediately as from the date of release. My concern is that there is likely to be a significant delay between the victim learning of the offender's release and the making of an order and its service upon the offender. That would potentially be a period of high risk for the victim, and this needs to be addressed by the Select Committee. Another point for its consideration would be the meaning of the term, quote, release from prison, unquote. Does this include release on parole or not? If not, then the victim may become subject to risk and may have to rely only on parole conditions rather than this new law. So let's have a look at that. I also have concerns about subsection 9(1), which says, and I quote, the court may make a non-contact order if it is satisfied that A, there are ongoing effects of the offending for the victim. Why does the court have to be satisfied that there are ongoing effects of the offending? What will the victim have to prove to satisfy that test? I don't think that the effects of the offending are really the issue here. It would be better for the subsection to require only, for example, that the victim reasonably believes that he or she may be subjected to unwanted contact by the offender. That is what the issue really is for the victim. So that's what the subsection should use as the test. Otherwise, it would be satisfactory to delete this test and this subsection altogether, because the other requirements in subsections 1b, c and d are sufficient by themselves, with the words, quote, ability to deal with those effects, unquote, being deleted consequentially from subsection 1b. Moving on to section 11, this sets out the effect of a non-contact order and prohibits the offender against whom it is made from having any form of contact with the victim. In addition, the court may prohibit the offender entering, living or working in a specified area. Mr. Speaker, the only concern I have with this section is that subsection 1C should be qualified by the addition of an exception as to entry, which is incidental to and necessary for the purposes of the offender's employment. I would also like the Select Committee to look at whether it is desirable to require, as part of this section 11, that the court is to specify an area only as large as is necessary to enable the offender and the victim to avoid contact with each other. While we need to make the order effective, we should also see that it does not unnecessarily cause problems for the offender in obtaining or maintaining their employment and carrying out his or her duties of employment. Finally, Mr. Speaker, section 15. This provides for a non-contact order to be discharged by the court if it thinks fit on the application of the victim or of the offender against whom the order is made. I suggest that the Select Committee look at whether the court should be required in this section, in considering whether a discharge of the order should be granted, to consider some specified matters, such as the record of the offender in complying with the order, the behaviour of the victim, which may itself justify a discharge, and obviously the places where the victim and the offender live permanently. If one lives in Australia and the other lives in New Zealand, then I would expect that would be an important factor in deciding whether to grant the discharge. Mr. Speaker, as I have said, New Zealand First does want this legislation. We do think it's necessary. We don't think existing laws are adequate to protect victims and their justifiable fears in relation to ongoing contact with an offender. So New Zealand First wishes to vote for this legislation, not only to go to the Select Committee, but hopefully thereafter as well, provided we can get the most effective law possible to protect victims from those ongoing risks resulting in unwanted contact by the offender. But as I've said, there are a number of ways in which the bill might be improved, which we wish to discuss, and I hope other parties and the government in particular are willing to look at amendments for those purposes.
The Honourable Kate Wilkinson.
Speaker, and it's a pleasure